Civil Code as a directive principle than the personal law. The Uniform Civil Code can be said to be a call for making of one law for the whole India, a law that would be applicable to all the religions and religious communities equally, whether it is a matter of marriage, it's a matter of divorce, inheritance, or adoption, or whatever matter. So the idea of Uniform Civil Code dates back from the colonial India, as I told you just now. The Lex Loci report that is stressed for the codification of Indian laws uniformly, and that codification was confined only in the matters of evidence, in the matters of crimes, in the matters of contracts, but this report is specifically recommended that the personal laws of Hindus and Muslims are not to be codified. Then B.N. Rao committee, who was the advisor to the constitution, also advisor, that committee was constituted to codify some of the Hindu laws in 1941. And that committee has also conferred with the task to examine the question of the necessity of common Hindu laws. The committee, in accordance with the scriptures and the available material, recommended that a codified Hindu law which would give equal rights to all, equal rights particularly to women also. And this committee recommended a civil code of marriage and succession for Hindus. So this draft of Rao committee, B.N. Rao committee report, that was submitted to a select committee, and that select committee was chaired by Dr. B.R. Ambedkar, and that came up for discussion in 1951, but it was lapsed at that time. Then it again submitted in 1952. And then after a great discussion at length on this report of this committee of B.N. Rao committee, somewhere in 1956, this was adopted. That was after independence. And you see that we have the Hindu Marriage Act, Hindu Succession Act, Minority and Guardianship Act, and then Hindu Adoption and Maintenance Act. All these acts collectively known as the Hindu Code Bill. And the laws related to different religious communities of the Hindus, they are also included in this Hindu Code Bill, which is also having the inclusion of the Buddhists, Sikhs, and Jains also. But the best thing of this Hindu Code Bill was that the women have been given the right to divorce and succession, and the caste has been termed as irrelevant. It was not a very relevant pointer for the marriage. And one of the existing evil, that was of the polygamy, that was also done away by this Hindu Code Bill. So this Hindu Code comes under Article 35 of the draft constitution. And that was renumbered as Article 44 in the Constitution of India. So the subcommittee on the fundamental rights, because we know that when the draft of the Constitution was being there, then many committees have been also formed to work for the Constitution of India. So there was one subcommittee on the fundamental rights also. So that subcommittee also submitted a report in 1947 April for Uniform Civil Code, which was discussed in November 1948. So the objections for the Uniform Civil Code also came for this article from Muslim members in the Constituent Assembly. And then one of the members, K.M. Munshi, he also defended the provision that it should be there. And Dr. B.R. Ambedkar, he also spoke at length. And he said that the civil code, Uniform Civil Code is desirable, but for the moment, it should remain voluntary. And this is why you see that the Uniform Civil Code was put in Directive Principles of the State Policy in Part 4 of the Constitution of India, which is not enforceable in the court of law. We all know that Part 4 Directive Principle is not enforceable. And this principle, this provision of UCC is put as Directive Principles of the State Policy. This Uniform Civil Code was incorporated in the Constitution. That would be fulfilled when we in India would be ready to accept it. This was the This was the observation of Dr. B.R. Ambedkar, because he said that the social acceptance of the Uniform Civil Code is very much required. Though he was also of the opinion that we are having in our country a uniform code of laws which covers almost every aspect of human relationship, whether it is a matter related to the uniform criminal code that is operating throughout the territory, whether it is a matter relating to the property. So we have the Transfer of Property Act, which deals with the property relations throughout the territory of India. We have the negotiable instruments also. So many of the laws, civil procedure code, those all were existing. But the only point where the common law is not available, that is the marriage and succession. And it is this little area, Dr. Ambedkar said, that we could not invade into this area of marriage and succession. And it is the intention of those who designed this, that is the subcommittee on the fundamental rights, that Article 35 of the draft constitution, this could be a part of the constitution which could bring some of the changes in the society. And therefore, Dr. Ambedkar was of the opinion that we need to do this, but it could be done only when the society is willing for that, because we cannot enforce any law on anyone who are not willing on that particular law. So because of this, we find that because of this voluntary acceptance or the applicability of this Uniform Civil Code, it was put in Part 4th of the Constitution, and it could not be made a law since then. So now we have Article 44, which provides that the state shall endeavor to secure a uniform civil code for the citizens throughout the territory of India. So we know that India is a country which is plural in nature, and the people have different faiths, they have different religions, and the makers of the constitution, while they were making the constitution, they were also facing these type of the problems, how to unify, how to integrate the people of India. Because they were professing different religious faiths, they were from the different caste, creeds in the society. They were speaking different languages. They were having different from different regions. And to provide a secular constitution to integrate all these sections of the society in one country, that is Bharat, was a difficult task. So this was simply, we know that the reason was the great diversity and plurality, and everyone has a fundamental right to the freedom of religion also. That's an enforceable right in Part 3rd of the Constitution. And further, we are a secular nation, and the personal laws of the Hindus and Muslims find their source from the authorities in their religious texts like Quran, Hadith, Ved, Quran, and so on. So here it is very important to discuss that the criminal laws in India are uniform without any consideration of the religions. They are equally applicable on all. And here I'm also reminded one of the judgment given by the Supreme Court in Pannalal Bansilal Pitti case, when the court held that the directive principles of the Constitution themselves visualized diversity, of course, and attempted to foster some of the uniformity among the people of different faiths. A uniform law was highly desirable. So the court was also of the opinion that there must be a uniform civil law, though we know that the enactment of that is in one go may not be possible, or it may be counterproductive to the unity and integrity of the nation. But in a democracy which is governed by rule of law, gradual progressive change and order should be brought about. Making law or amendments to a law is a slow process, and we all know that the legislative attempts to remedy these things are required urgently, because there are many questions relating to the Uniform Civil Code. Particularly, the first thing is that do we need a uniform civil code? And if yes, then why we see that the Uniform Civil Code is not a part of the legislation till now? Why there are a lot of debate in favor or against the Uniform Civil Code? Or is civil code merely a political agenda? Because for the last few months, we are again having this idea of the Uniform Civil Code, that it should be there. Many of the states in India, they are also moving forward for making a Uniform Civil Code. Then will this Uniform Civil Code help in establishing national integration by avoiding contradictions on the grounds of various ideologies? Because we have adopted the Constitution in 1949, 26 January, whereby we have also assuring for the promotion of unity and integrity of the nation. So in that scenario also, whether this would be helping in national integration, whether the Uniform Civil Code is a step forward towards integrating and strengthening the secular ideals of the India, because secularism is a part of the Indian Constitution through its preamble. And the, as I told you, the fundamental freedom of religion is also available. Then whether this Uniform Civil Code will lead to the violation of the personal laws, this is also one of the important questions. Which is always coming forward whenever there is any attempt to make the Uniform Civil Code, whether the personal laws fail in their domain of religious commune. That is a question which needs further thinking. Whether this UCC will bring a unified India, which may be resulting into gender equality, because whenever we talk of the Uniform Civil Code, always there is a question of the gender equality, that the women in the other personal laws, they are treated unequally and they are not being given their proper dues, their proper rights as are available to other women in the other communities, religious communities particularly. So whether this Uniform Civil Code will ensure the empowerment of the women in true sense by ending the practice of polygamy. Polygamy, we all know, which is highly unfair and discriminatory to the women. So there are many questions, but one of the most important point is that this directive principle is still what the Supreme Court has also said is an unaddressed constitutional expectation, which the state must endeavor to secure for its citizens. And if we look around, then the concept of the civil law can be traced back to the Romans. The first European country was the France, where this when they have codified the civil laws. If we see internationally and globally, then we find the UK, China, Canada, Australia, US, Russia. There are many more countries which they have the codified civil laws. Leave the foreign countries. We in India also have a common civil code in Goa. Because Goa is said to be the first state, as Dr. Pallavi also introduced, this uniform civil code is there in Goa. So that is applicable there. Since 1994, this Special Marriage Act is available there. And this Uniform Civil Code was introduced by Portuguese in 1870 as Goa family law. So we find that the directive principle, which has been given the positive response from the legislature and judiciary in India, in some of the states. Now we are witnessing that in Uttarakhand also, you see that the chief minister there has appointed a committee which is headed by one of the retired judge of the Supreme Court, Honorable Mrs. Justice Ranjana Desai, to look into the matter of making this uniform civil code for their state. Then there have been many judgments also. The judiciary has also come with this reference of uniform civil code, whether it is a case of Sarla Mudgal, Lily Thomas, Daniel Latifi, then John Vallamatrom, Shavanu, of course, is a case on that point. And then Pannalal Petti, as I just discussed, the reference of that S.R. Bombay case on the basis of the secularism, the court discussed on this point also. And Seema versus Ashwani case, that has shown the intention of the judiciary also for a common civil code or a uniform civil code.
This meeting is being recorded.
And you see that in Maharshi Avdesh versus Union of India case was filed before the Supreme Court to issue the mandamus to the government so that the government may legislate on the uniform civil code. However, you see that the Supreme Court cannot issue the mandamus on the legislature to enact a law. This is entirely in the regime of the legislature to enact a law. So of course, this writ was not writ was rejected of Maharshi Avdesh. But you see at this stage, uniform civil code throughout India is the need to promote the principle of justice, the principle of equality as enshrined in the Indian Constitution, which are also the preambular objectives of the Constitution of India. So to live a truly unified and harmonious society, we find that each person is to be treated equally. They should be given the justice. So this accepting and enforcing a uniform civil code can be said to be one thing which is really required, direly required, urgently required. This is my personal opinion. But I think that as a citizen of the country governed by rule of law, law should be equal for all. And you see, one attempt has also been made towards the codification of this uniform civil code. And a private member bill was introduced in 2018 that Shri Chandrakant Kher MP to provide for the constitution of the National Inspection and Investigation Committee for the preparation of uniform civil code. But that could not result in a very mature, or that could not be materialized as yet. But we find that the present or the current agenda of the government, which is working on to unify all personal laws for all religions and castes, and that seems to be clear, because the government believes that the real progress of the country, that should not only be dependent or confined only to the progress which is said to be a political progress, which is said to be the economical progress, but it should be a progress in the social aspect also. So everybody should be treated equally. They should get justice. There should be dignity of all the persons, male, female, whatever. And that's why we find and we feel also that this objective or this principle, directive principles of the Constitution of India, which find way in Article 44 of the Constitution, that should also be given the shape of a law, like other provisions of the directive principles part in Constitution, where the legislature has come forward and enacted the law, whether it's right to education, right to work, and right for the vulnerable group, maternity benefit, child rights. Many rights have been created by codification as well as by interpretation by the judiciary of Part 4th of the Constitution,